welcome to the first set of paper presentations as a part of the International Research Conference on Insolvency and Bankruptcy. So I'll just familiarize you all with the rules briefly, and then we'll begin with the paper presentations. Each paper presentation would last for 20 minutes. There are a total of 4 paper presentations in this session. After all the paper presentations get over, which is after all the 4 paper presentations get over, the dais can be open to questions. So you can ask your questions for 15 minutes after the paper presentations get over. At the end of the paper presentation, I would be ringing a bell so that you would be kept aware of the time passing by. So to introduce our judges, we have Shri Santosh Shukla, who is the Executive Director of the Insolvency and Bankruptcy Board of India. And we have Professor M.P. Ram Mohan. He's the Associate Professor in the Business Policy area at IIM Ahmedabad. The first paper looks at assessing behavioral change of creditors under IBC. This would be presented by Dr. Neeti Shikha and her team consisting of Dr. Shambhavi Singh and Dr. Rishabh Ahuja. So we will begin shortly. We'll just set.
We are still students.
Okay. Okay, we were given doctors with apologies. I hope that's fine. I'll just begin the timer so you have the slider here. Thank
you. All right then, so good afternoon everyone, esteemed panelists, researchers, scholars. I hope everyone is refreshed after the lunch that we had. Today we are gathered here at the International Research Conference on Insolvency and Bankruptcy, and the paper that we are here presenting is titled Assessing Behavior Change of Creditors under IBC. This paper has been written by Dr. Neeti Shikha, who is the Associate Dean at the Indian School of Public Policy, along with Shambhavi Singh and I, who are current students at ISB, at the aforementioned institute. The objective of this paper is to argue that the Insolvency and Bankruptcy Code should be analyzed through broader frameworks such as behavioral economics. The point was also earlier made in the inaugural session by Mr. Rajesh Verma, Secretary of Ministry of Corporate Affairs. Now, I want to establish some context at the start of the presentation. Everyone here would know what it was like before IBC was introduced. Former Chief Economist, Dr. K. Subramaniam, had said that before IBC, there used to be a feudalism where the corporate debtor took it to be his or her divine right to be in control. This was because of several ineffective laws that were not able to provide a dignified exit to businesses, and promoters being in control of their assets indefinitely, much like feudal laws of the 17th century. The resulting debtor in possession framework eventually led to a large increase of non-performing assets, harming the banking system and the wider national economy. With productive assets not being appropriately utilized. These inefficient outcomes reflected the skewed behavioral dynamics between the creditors and the debtors. And the IBC was introduced to remedy that, making it a behavioral policy as well. This brings us to the discussion on behavioral economics in the policy world. Behavioral economics incorporates insights from psychology to economics in order to understand how humans behave rather than how they should behave. David Friedman, in his book Law's Order, What Economists Have to Do with the Law and Why It Matters, had said that legal rules are to be judged by the structure of incentives they establish and the consequences of people altering their behavior in response to those incentives. That is, legislation, when designed appropriately and enforced efficiently, can adequately incentivize self-interested economic actors to choose the most desirable or the most efficient outcome. This means that for a policy to be successful, There has to be a confluence between the self interest of the economic agents and the desired outcome. IBC has sort of achieved this with thousands of debtors resolving their financial distress at the early stages of the process. One reason for this is loss aversion. In behavioral science, it has been found that losses loom larger than gains. That is, the psychological pain of losing is twice as powerful as gaining something. Therefore, when the promoters of a firm are divested of their rights as soon as the corporate insolvency resolution process begins, they try to resolve it as soon as possible. Another thing that the code has done is to provide a choice architecture. A choice architecture is a term coined by Richard Thaler and Cass Sunstein in their famous book Nudge. It refers to the practice of influencing choice by organizing the context in which people make decisions. For starters, the IBC gives businesses an automatic choice of resolution while also giving them an option to depart via a withdrawal application. Now, Shambhavi, my co-author, will continue with this presentation.
Thank you so much, Rishabh. Good afternoon, everyone. I'm now going to be explaining how the change in default threshold led to a significant change in the behavior of creditors and further led to reduction in filing of petty claims. So with the onset of the unprecedented COVID-19 pandemic, the Ministry of Home Affairs, in tandem with state governments, on March 24, 2020, declared a complete nationwide lockdown in its effort to contain the spread of the pandemic. Thereby, all economic operations were brought to a complete halt. So at this stage, the government had permitted only certain essential activities to be carried out. Due to which the central government was well aware of the fact that there would be financial repercussions and distress in this extraordinary circumstance, and therefore the MCA, in order to provide protection to the industry as a whole, used its inherent powers under Section 4 to raise the threshold to the maximum limit of 1 crore rupees on March 24th, 2020. The sustainability of the cash flow and the generation of profits was rendered extremely difficult and the cause of tremendous worry as a result of the lockdown. Adding constant salt to this injury was the fact that the duration till when the pandemic would last was not foreseeable, which further created an immeasurable sense of helplessness within the stakeholders. In the prevailing circumstances, it was conceivable that the businesses might not be able to discharge debt expediently, and as a result, the defaults were attracting the invocations of the provisions of IBC, which would inevitably lead to a rise of massive proportions, which would push many businesses to insolvency. It has to be remembered here that the objective of IBC was never to liquidate or close companies, but in fact to find an effective and balanced resolution where a stressed company would be able to discharge the debts owed to its creditors and eventually overcome adverse situations to realize its economic potential. Therefore, in order to aid the distressed businesses in the extraordinary circumstances, the President of India on June 5th, 2020, promulgated the Insolvency and Bankruptcy Code Amendment Ordinance 2020, which inserted Section 10A in the IBC, by operation of which the rights of creditors to initiate CIRP against corporate debtors under Section 7, 9 and 10 of the IBC with respect to defaults arising on or after 25th March 2020 was suspended for a period of 6 months or such further notice, not exceeding 1 year from 25th March 2020. Section 10A of the IBC was only operative in relation to defaults of debt payments that have occurred after 25th March 2020, and it did not provide for the protection of debtors who have defaulted in their payments of liability that arose prior to the said cutoff date. The induction of IBC also led to an exploitation of the lower threshold limit set by the Act, and the parties started initiating the CIRP even for petty claims. And however, this attitude was changed once the threshold limit was increased from 1 lakh to 1 crore rupees on March 24, 2020. We have sourced some data from the IBC newsletter which establishes the same. For example, if you look at this graph, we can see that the withdrawals under Section 12A of the IBC, as well as the appeals, reviews and settlement together, they account for almost 53% of the closed CIRP. So this clearly represents the fact that most parties prefer to settle their claims instead of going ahead with the liquidation of a company or accepting the insolvency resolution plan. A behavioral change can also be clearly observed in the above data in the operational creditors. Next slide. Yeah. So in this figure, we can witness the fact that 54% of the CIRP were withdrawn by the parties involved, and those cases amounted to a default of less than or equal to 1 crore rupees. It verifies a definite behavior change brought about in such situations wherein defaults by companies that were not in an actual insolvency state were settled once the CIRP was started, and the debtor could potentially lose control of their firms. Next slide. So in this figure, there are various reasons that are listed for the withdrawal of CIRP under IBC. It states that the major reason for such withdrawals can be amounted to the settlement of claims amongst the parties involved. These figures indicate the fact that with a lower default threshold, creditors, especially operational creditors, settle their claims, indicating the fact that the borrower had the capacity to settle and initiate CIRP, and this acted as a nudge for them. The company was not exactly in a true state of insolvency. Now Dr. Neeti Shikha would continue further from here.
So, thank you, Shambhavi. Let me share with all of you that how this inspiration for the work came. I had written a piece for Bloomberg Quint, and we went to and fro because I had made some suggestions which the editor-in-chief, very, very known and well-read editor, she was not agreeing with me. My claim was that, especially when the standing committee said we should bring a code of conduct for creditors, the question that I asked myself is this the right way to incentivize insolvency, regime? So from that questions and interaction with the Bloomberg editor, I involved my students because that's what I do. I'm a teacher, so also encouraging the next generation to research with me. We said that, okay, we talk about IBC bringing a behavioral change. How do we measure that? So and what kind of behavioral tools have we used it? So everybody has spoken about it. Mr. K.V. Subramaniam has spoken about it, but nobody has given us evidence or data. So what we did was we tried to see where do you see the effervescence of behavioral change and tools? So one was that lower default threshold incentivized people to, it sort of nudged creditors to take a case and also sort of nudged the debtors to settle their claim. And the data sort of showed that. We reached out to IBBI to ask for two types of data, because if you see in the whole process of CRP, the two stages where the settlement is happening. One is happening at the stage before the admissions, when the cases are filed but withdrawn, and the second is under 12A. So we got the data for 12A, and this is a work in progress. We're looking at the different sectors, bench-wise also, and seeing where the settlement have sort of happened most. And we are still reaching out to various sources to get the data for the settlement before the admission. But while we were doing this exercise, we found IBBI newsletter, which clearly showed that more than 50% of these cases are being settled. So the question that we have to ask ourselves now is that the fact that we raised the default threshold to 1 crore, is it a right policy approach? Because data shows that lower threshold was nudging people to settle their claim. I may not be able to answer with certainty right now because IBC was suspended and we still have to get data for the period post, the default threshold was increased. I also went to read a lot of literature. Now, if you see, the American literature is full of behavioral economics tools being used for insolvency. And one of the study we found was by Daniel Moken and Nina Hager. And what they did was they tried to lower the default, credit card default, by using behavioral tool. And what they did was in the IVR menu, they just put it up certain ways. For example, the bank would make a call and say, what is the likelihood of default? So in their work, they identify two types of delinquents. One is who will not pay the credit card bill. The other group of people were who may have forgotten to pay or who may have tendency to forget to pay the credit card bill. So in the menu, they would ask questions like, will you be paying in next 3 days? They came back and they tweaked the IVR. And they asked question like, are you committed to pay in 24 days as you had said? And it's a very thoroughly researched paper, and they found that the overall default on credit card decreased by 2.6% by simply changing the way IVR was designed. So taking cues from there, I'll not take much long because it's work in progress, and I hope Shukla sir will allow me maybe next year when the paper is complete. We looked at what are the tools of behavior change, what are the tools of behavioral economics that could be used. So of course, one was aligning incentive. Now, we had to look at various stakeholders and see where the gaps are. Now, a lot of brouhaha about committee of creditors, COC pushing towards liquidation. I've written very vigorously about it in various newspapers, and I still maintain that liquidation rate is not the way you look at an insolvency regime. Germany has the most sophisticated insolvency regime. It has 90% of the cases under their insolvency goes for liquidation. So even if you save one company, you have done your job. So I really applaud IBC on that point. So, however, how do you incentivize? One way I thought could be, and I think that is where my discussion with the Bloomberg editor started, was that if you understand what is happening in the current situation is that when the borrower has defaulted, they go to negotiate their settlement. Now, if you look from psychological and from science, behavioral science perspective, they already lost the game. They lost skin in the game. So the bargaining power of borrower is lower as compared to the creditors. So my suggestion was, in the inter-creditors agreement, can we give as a matter of right to the borrower to have OTC, which anyways RBI allows, OTS, one-time settlement. Now, when they go for one-time settlement as a matter of right under the ICA, creditors will not push for higher haircut. Also, we are incentivizing the borrowers to announce predictability of default, which may have not occurred yet. Why? Because there is no pains for announcing that they have probability of default occurring. So under an ICA, if a clause could be inserted, and I've reached out to my GIP students to discuss what are your thoughts on that. Of course, some of the students who are working with banks discouraged me and asked me, don't write about it. But I thought it's an academic place, we must talk about this. The other is choice architecture. The choice architecture suggests that we have to give choices to the borrowers and creditors. Now here, even under PPIRP, the pre-pack regime, we are making it so code cumbersome. So can we find a way where we give choices to people to restructure outside court as well as inside? And I'm really happy to see that mediation is now coming as a precursor. That is strengthening the choice architecture. What we need to be careful about is, with all respect to the NCLT, NCLAT, if one stakeholder which is failing IBC is the courts, and I understand their problem also. There's a problem with them. They have a lot of structural limitations, but they're failing. I did a study for IBBI, and we found that maximum delay is at the stage of admissions. So anyways, coming back to the point is that you give choices which is not involving courts so that the finality is reached. In the morning, we were mentioned about giving right to shareholders. That's a discussion for another day. But evidence shows that DIP model has not worked for India. BLRC itself says 4.2 years was average time taken by cases to settle. So I don't think we have to change the DIP model. We just have to align the incentives right. So choice architecture, aligning incentives right, and looking at the ICA and addressing the problem of probability of default within the intercreditors agreement. So these are the three aspects we have taught, and this is a work in progress. We are happy to have any comments that you have on this. I think, yes. Time is up? So, if I am within the time, then I hope that the panel will applaud us for being well within the time. Yes, sir. Yes.
What the IBC has changed, that is mostly or action, legal action from NPA date to default date. So almost 90 days preceding the NPA date. But if you go into the question of, as you said, why a borrower will default, we should go into that question also. You have partly gone into that. As a banker's view, I'm sharing with you. See, it is kind of an option when a bank gives a loan to a borrower. Basically, it is selling an option to the borrower to default or not to default. As simple as that. If I have taken money from the bank has taken some collateral from me, or maybe a clean loan, like a personal loan. So now it is up to me, should I pay or should I default? That's an option available with me. Right. Now, every option has a strike point, strike rate. What is the strike rate here? Strike rate is the collateral available with the bank, which may be in the form of my reputation. Like earlier in my previous generation, people never used to default because it was a clan and they feel that in the society they'll lose face. But in my generation, today's generation, that kind of clan culture has gone. We are into nuclear families. Even if I default, my neighbor doesn't know I have defaulted to the bank. I'll get some mail in the mailbox that you're defaulted and I'll take action. Nobody in the society knows. So how to create incentive in this situation? Because sometimes what happens when I give the loan, I take some margin. So my loan is 100 rupees. My worth of collateral is normally 125. That is what we do in bank. Over a period of time, the value of loan goes up. Like I give some increments, enhancements. It may be due to non-payment, some interest accumulates. It becomes 125, whereas the value of the asset goes down. Valuation can go up and go down in a dynamic market anytime. So the problem comes when this borrower thinks that today the value of my collateral with the bank is lower than what I owe to the bank. I have seen that in the last few years when the property market was down. Lot of collaterals given in the form of real estate, the value went down considerably. Due to that, many borrowers came to us, sir, we cannot pay. You enforce my asset and take away, because he was not able to sell that in the market. So how to create incentive in this situation where borrower is in the money. If he defaults, he is in the money. He has the option to default and he is inclined to default. Whereas banker, ultimately, he takes him to the court, and then second point you said the ICA or the agreement. Second point is how to enforce the agreement in a situation in India where enforcement of agreement is a
big task. So thank you sir, to answer your first question. One way we suggest in our paper is creating echo chambers. That's one tool that we use in behavioral science. So so we suggesting ways how echo chambers could be created for the borrowers as well as creditors to reinstate and reduce the probability of default. Coming from an academic side and understanding the philosophy of contractual bargains very well, I strongly believe that banks should not be staved at the, with all respect to all the bankers here, at the point, courts are not bound to save you out of a bad bargain. That's a fundamental settled law across the globe, that courts are only interpreters of contract, not makers of contract, and they'll not save you out of a bad bargain. So banks have you bargained wrongly. So one way banks could have done is, at least what they do outside India, is that they'll diversify the portfolio, they'll keep they'll be active participant. Like in long infrastructure contracts, you'll have one of the members sitting on the board being actively involved in that. So one of the papers I submitted to IBBI last year in the annual report was that can you think about a way that corporate governance is strengthened before the default rises? Because everybody's talking about insolvency when the default has happened. The conversation should happen when the contract is sort of entered into, so that there's no default happening. But I understand the problem is because banks are also under a lot of pressure to lend in a, especially priority sector. So I think this kind of freedom, banks also don't have to choose who they want to lend and all that sort. So we are working on our suggestions on how to create echo chambers, one of the tools used in behavioral science, and we'll be very happy to share with few of you volunteered, and you tell us what is the workable solution for those, because we are coming from very, very theoretical standpoint. We're not sure about its workability in the court. So that is all that we have to say, and we'll rest the presentation here. Thank you so much for your patience listening.
Thank you, Dr. Shikha and her team. I'd like to inform that they were well within time limits. The presentation was well within time limits, and the question answer session took about 3 minutes. So just in order to be fair, I think henceforth, after each presenter, they should be allocated a time of nearly 5 minutes for answering questions. The next presentation is on interim finance in creditor-oriented bankruptcy courts, a study in the context of IBC India. It would be presented by Mr. Amol Bakshi.
This is for forward, this is backward.
Yes. Should I do it over here?
Okay, that will be nice of you.
I would just, this is the answer. Okay.
Good afternoon, respected panelists, distinguished members of the audience. I am presenting a paper on topic on interim finance and credit-oriented bankruptcy codes, a study in the context of IBC India. I thank IMA and IBBI for giving me this opportunity. My name is Amol Bakshi. I am presently doing my PhD at Indian Institute of Foreign Trade. Apart from my PhD, I also possess work experience in the NBFC sector in the areas of structured finance and stressed asset management. Just to briefly describe how I've organized the presentation. In the first few slides, I will briefly discuss the motivations for research, objectives, methodology. I'll briefly outline interim finance under both IBC as well as the DIP model. I'll present the first finding, which are the distinct dimensions of interim finance both in DIP and credit-oriented codes. I'll then discuss the results of the qualitative methodology which I've used, which are basically interviews to identify the issues and challenges of interim finance market in India. And I will integrate this to present the discussions and conclusion. Now just coming to the motivation for research, what motivated me to pick up this topic and examine it further is that interim finance is extremely important to the bankruptcy process, and lack of interim finance can significantly delay the process and also threaten the going concern status of a corporate debtor. This is well established. Even in the morning session, there were references made to interim finance and its importance. Enabling legislation allowing interim finance and according repayment priority to interim finance lenders is recognized as a good insolvency practice. And even in the World Bank Doing Business report, they used to measure strength of insolvency framework. One of the indicators was the ability to raise interim finance. Now the World Bank DBR has been discontinued, but this was one of the, it is an established indicator for strength. There's also a lot of debate ongoing on the efficiency and effectiveness of bankruptcy codes. So the subject of interim finance becomes even more relevant as an important input to the bankruptcy process. While there is significant literature on DIP finance and the debtor-friendly codes, we find there is less known about interim finance in creditor-oriented codes. So when we talk of debtor-friendly codes, we are essentially talking of a insolvency regime where the debtor remains in possession. This is against creditor-oriented regimes where the existing management is suspended and a court-appointed professional or a resolution professional is appointed. So this paper essentially tries to examine whether there are distinct dimensions between the two forms of financing and the two different insolvency regimes. And also the one last motivation or significant motivation is that the segment remains challenging despite enabling provisions, with many insolvency professionals struggling to raise interim finance for the CIRP cases. The objectives of the methodology are twofold. One is to answer the research question whether interim finance has distinct dimensions as compared to interim finance in the West under DIP model, to analyze the practical issues and challenges in raising interim finance in India. For both, qualitative methodology has been employed. For the first objective, it has been primarily through the theoretical lens. In the second objective, I engaged with interviews with a group of insolvency professionals on an individual basis, and also some select lenders. This methodology was adopted to finally identify practical challenges in this sector. Please. In the next 3 slides, I'll very briefly touch upon the requirement in interim finance, which all of you would be, I'm sure, well abreast of. Interim finance is known by many names. It is also called post-commencement finance, post-petition financing. It refers to finance raised by insolvent corporate debtors during the bankruptcy process. This can be either raised at the commencement of bankruptcy process, or it can be raised during the CIRP process. The main objectives of interim finance are to meet various costs during bankruptcy. It so happens that during the CIRP process, bankruptcy process is called the CIRP process in India, so I'm using the terminology. The corporate debtor may not have any cash flows or any bank balances, which is often the case. But there are routine expenses to be run to maintain the company as a going concern. Apart from that, there are CIRP costs also to be met. So interim finance from an external entity becomes very important to ensure continued operations of a corporate debtor, to protect and maintain value of assets of corporate debtor, and support survival of a firm through reorganization or going concern sale and liquidation. This has been recognized as an objective of interim finance. Now, the IBC has enabling provisions to allow RPs to raise interim finance, subject to monetary limits prescribed by the Committee of Creditors. Of course, if security has to be provided, the insolvency professional needs the approval of the Committee of the Creditors. Any interim finance raised is recognized as part of CIRP cost, and so priority status is given to take out of this interim finance in the waterfall mechanism. This is also a very important aspect of interim finance recognized internationally, that if you want to motivate lenders to lend interim finance, you have to accord them priority. Otherwise, nobody will lend an insolvent corporate debtor. There was also an amendment in 2018, where in the event of liquidation now, interest for 12 months post liquidation commencement date is allowed as liquidation cost, and that is also accorded priority. I'll briefly touch upon DIP financing. Now debtor in possession financing is a form of interim finance in debtor-friendly creditor bankruptcy codes, and it has been very popular. As per research, over half of the corporations in America, in the US, have raised debtor in finance, those corporates that have filed for bankruptcy. It is defined as a special type of court-approved financing extended to firms filing for reorganization under Chapter 11 of the US Bankruptcy Code. Now, the US Bankruptcy Code has distinct chapters, one for reorganization and one for liquidation. And companies that are normally referred to under Chapter 11 are normally do so with a prior financing plan in mind. DIP lenders are allowed super priority as well as security status. And on analysis of literature, it was found that the literature around DIP is quite extensive, and it is quite legal in nature, given the topic. But it has been around three major points. One is the importance of DIP financing to the process. So literature has found that DIP financing is very important to efficiencies of bankruptcy outcome. It reduces signaling. In fact, when companies which have listed companies which have announced that they are raising DIP finance, they have found the stock prices to significantly increase upon announcement, because it indicates the reorganization prospects of such corporate debtors. There have been discussion on limitations, that it induces overinvestment because corporate debtors have funds, insolvent debtors have otherwise access to fund. It also induces security top-up by existing lenders, which is called roll-up, where existing lenders use DIP finance as a means to augment their security. The second type of category of analysis has been done on type of firms that receive DIP financing. Some research has said large firms are better off receiving DIP financing because they have greater information availability. Of course, small firms also get DIP financing, and it largely depends on the motivation of lenders. For example, hedge funds and private investors which seek control of a firm may prefer to select small firms from an ownership point of view. And the most important aspect of DIP financing has been control governance implications. In fact, it has been described as the most important lever by which lenders exercise control and governance on an insolvent debtor. They do it for two reasons: to balance the debtor friendliness of the code, and also for control motivation. So these are the dimensions of DIP financing. Now I come to the analysis of the distinct dimensions of interim finance in DIP versus creditor-friendly codes. While both forms of interim finance are important, it is very essential to understand the differences in order to better appreciate the nature of interim finance under creditor-friendly codes such as IBC India. If we talk of the conceptual basis, as Chapter 11 companies typically get DIP financing at the outset is for reorganization. Whereas when we talk of IBC in India, at the outset there is no clarity whether a company will be reorganized or a company will be liquidated. This is something that gets decided during the CRP process. So the funding is typically raised during the CRP process, and the uncertainty element is a little higher, one can say, or one can in the CRP regime in creditor-friendly codes. When we talk of timing of raising DIP financing, research literature has shown that majority of the companies raise DIP financing very early in the process, sometimes even prior to admission of bankruptcy by the pre-petition lender, or at least within 30 days upon admission to bankruptcy courts. Now when we talk of approval process, in DIP is a court approved process. The court has significant powers. They can even they can even allow security sharing with existing pre-petition lenders. This is unlike the case of India, where it is creditor driven and controlled by the committee of creditors. And the most important is motivation to lend. This analysis has found that relationship lending and control and governance are two major motivations for DIP lenders, because the debtor continues in possession. So lenders typically continue the relationship motive angle and lend money to the company because they know the debtor, if it is reorganized, will continue in its existing form to control possession of the debtor. And in terms of control and governance, that is also a motive which we have discussed. But in the case of creditor-friendly codes, such as IPs, this paper argues that since the RP is in control, there is no question of control and governance motivations of lenders. Control and governance rest with the RP who is managing the affairs of the company. And relationship lending is significantly diminished in creditor-friendly codes is the argument of this paper. Now, for the second findings relate to the results of the discussions held with resolution professionals to find out the practical challenges they have faced in mobilizing interim finance. I'll briefly run you through before discussing from a larger perspective. From an importance perspective, majority of the respondents perceived interim finance to be very important to the CRP process. And some people even mentioned that, some RPs even mentioned that certain expenses are so critical and funds are lacking, the lack of funds, they have to meet the funds through their personal corpus. In the question of ease or difficulty in mobilization, majority expressed that interim finance is very difficult to mobilize, and it has been divided into two categories. We have divided this, we asked them the question whether it is for lack of willingness of external lender or is it from the COC side. Where are the practical difficulties which lie, which I'll discuss subsequently. They also mentioned that apart from participation, it is very difficult to get NOCs from existing COC lenders to raise external finance from outside lenders. The other practical difficulties, finance is often at a very high interest rate, and even where it is available, the DD time is so much DD time is taken because the insolvent debtor is being lent to, that it defeats the very nature of interim finance. Some respondents said it's easier to raise finance for firms having hard assets, but some differing expenses were provided on ease of raising for running companies. Some respondents felt running companies get easier interim finance. Some felt that it is more difficult because prior to, it's more difficult because it is not the lender's responsibility to fund salaries and other going concern expenses. Now, I also checked up on the specific issues from the perception of the respondents on the issues from the external lenders and issues from the COC. From the external lenders, the main problem that has emerged from this study is lack of takeout visibility. Now, takeout visibility is divided into two aspects. One is the quantum of takeout visibility, and the second is the timing of takeout visibility. In terms of quantum, there is uncertainty on liquidation or reorganization outcome. There is a perception that the CRP costs are very high compared to the recovery proceeds. In terms of timeline, which is most respondents said they do not know when the CRP process will get over, and there are judicial delays. Not only, it is not the question of saying it is the fault of the judicial, not like that. There are delays in the CRP process. Lenders cannot extend perennial financing. There has to be some limit of repayment, etc. There is lack, and second, they mentioned lack of participation from COC. They feel that the external lenders are unwilling to participate. where there is a, if existing lenders are not participating, they do not get comfort on the reorganization prospects of the corporate debtor. And third is the lack of incremental security. Now from the existing COC side, as somebody mentioned, I think in the presentation earlier, unwillingness to throw good money after bad. That is the primarily demotivating or rather a hurdle why existing COC lenders are reluctant to lend interim finance. Takeout visibility, of course. COC perception of interim finance as a stopgap arrangement or just for recovery. So there is a lack of holistic view of interim finance and how interim finance translates into protection of value of debtors' assets, and from there it translates into recovery. If it is just being viewed currently from a perspective of a going concern expense to meet normal CRP expenses without looking at the larger picture. And composition specific nature of COC lenders, there was some feedback received that this is also an important aspect. For example, if the COC lenders comprise ARCs, or they may have specific mandate where they are not able to lend to interim finance, that is also a major roadblock. One disconnect which emerged was the definition of interim finance. I have looked at the interim finance to mean external as well as existing COC members. However, some respondents said that interim finance raised from lenders cannot be construed as interim finance technically, because existing lenders typically provide an advance and they don't charge an interest rate. But then this was clarified at the outset that it is more of a technical in nature, and the interim finance refers to all forms of finance or funds raised during the CRP process. Some lenders were engaged. The feedback were more or less the same. Only two perspectives emerged. The lenders are very cost conscious, obviously, having lost money already, and they therefore believe that the CRP costs are stretched compared to the recovery prospects. There is some inherent tension between the RP and COC. One lender felt that allowing interim finance early will not provide the RP any incentive to squeeze one can say stretch the assets of an insolvent debtor and extract as much cash flows which are available. Now, in terms of normative suggestions received from respondent, they have broadly been on the COC side and regulation side. COC side, definitely most respondents said that the COC has to contribute, it has to be made compulsory. There are some alternate perspectives received that we cannot force commercial decisions on COC lenders. They are governed by RBI and their banks, etc., and it is not prudent. From a regulatory perspective, some suggestions were offered that allow IPs to raise without COC approval once the budget is finalized. Allow some corpus support from regulator. Let IBBI provide some corpus. And market is NBFC oriented. There should be policy impetus provided to banks for provision of interim finance. Now, putting this all together, I'll come to the discussion and conclusion, just ending right now. This paper finds that the barriers of high interest rate and security demands of lenders of interim finance are essentially symptoms linked to larger structural issues facing the interim finance market. At the outset, regulatory clarity may be provided on technical inclusion of the COC funding towards the interim finance definition. Whether COC funding can technically be incorporated as interim finance, but this is more technical in nature, but it will provide more homogeneity in the community. As far as the lack of visibility on takeout and timing of takeout is concerned, this can be said largely to be linked to the efficiency of the bankruptcy code, sir. And once the other issues of the efficiency of the bankruptcy code, such as the timelines, etc., are sorted out, the author feels in this paper that certain structural issues can get resolved, and this will give lenders more confidence to lend. Support of COC is very critical. The narrow perception of interim finance just being a stopgap arrangement dealing to asset value protection and ultimately recoveries remains a bottleneck. So greater stakeholder engagement can broaden perspectives. Coming to the tensions between this RP and the COC, the RP is guided by resolution, as many esteemed panelists speakers have earlier spoken, that the primary objectives of IBC are resolution. Lenders are guided by recovery. Now, this is an inherent conflict in the code. It cannot be altered. In fact, one research paper, I remember reading, I forget the author, he said nowhere is the conflict among creditor classes the greatest as in a bankruptcy process. Now, but however, this paper recommends that a greater ex-ante consideration by lenders of broader objectives of IBC and associated dimensions, such as interim finance, is necessary, preferably prior to triggering of the code to reduce ex-post conflict. So lenders, when they trigger a bankruptcy code, they should understand the dimensions of interim finance and its requirement, and taking a leaf out of DIP, more upfront planning for interim finance along with identification of suitable type of lenders will save time during the bankruptcy process. DIP, as I mentioned earlier, is tied up very early in the bankruptcy process, sometimes even prior to triggering. For borrowing best practices from that, this can be thought of as more of a normative suggestion for lenders who trigger the bankruptcy process. As noted by a well-known researcher, triggering bankruptcy without thought of funding is recipe for trouble. Now, interim finance makes sense for supporting reorganization of viable firms, so enabling sale as a going concern and liquidation. Now, more research is required on the role of CIRP, firm profile. Differing firm profiles will meet with different success in terms of raising CIRP. And heterogeneity of COC, how does it impact the success or ease or difficulty in raising interim finance? These are suitable research areas for IBC under credit-oriented codes. These have been significantly debated under DIP model. Coming to conclusion, there is little doubt interim finance is important. Interim finance under creditor codes have inherent limitations and need to be viewed in perspective, distinct lens. Takeout visibility, uncertainty, lack of holistic view of interim finance and differences in objectives of RPs are some of the important bottlenecks which we have discussed. Can be improved with better functioning for IBC efficiency and greater stakeholder engagement for aligning objectives. The greater ex-ante consideration by lenders of objectives of IBC and its associated dimensions while triggering code and more early consideration can reduce ex-post conflicts. Analyzing borrowers' health and reorganization prospects will contribute to systematic approach to mobilization, because different lenders can be approached for different types of insolvent debtors. It is not that only one type of, so a more systematic approach is required while solving the insolvency process. Now, well, many normative suggestions were received on forcing COC lenders to participate in the corpus funding or interim finance. It is recommended to find a more balanced view with larger universe of IPs and lenders. This study's limitations, like all studies have limitations. This study limitations was it could not access a very large universe of lenders and IPs. Lender community is largely very heterogeneous. You have to look at NBFCs, you have to look at banks, and you have to look at different types of investors, and each will have the differing objectives. One cannot paint with the same brush while selecting the sample. And lastly, a monitoring metric is suggested, where maybe one can look at some database of debtors, corporate debtors, which have been successful in raising interim finance and what their outcomes have been. I tried to get this data from published sources. I was unsuccessful. I requested IBBA, but I think if we can, thank you very much.
I just want to note your time, but if you want to continue.
No, I'm okay. Any questions, please let me know.
But as I understand, because interim finance get a super priority over all other types of, it's a CRP cost, part of CRP cost. So security is a non-concern. Because in any case, whether you have a security or no security, you are paid upfront. So security is non-issue here. Second question is where to sanction. Which particular CRP should we sanction this interim finance, where not?
Yes.
Because bank, when is taking a new exposure, it has to be very careful. We cannot just throw, as you said, good money after bad money. So there are many cases which it's clearly visible that they are going into liquidation.
Yeah.
So I may not be getting, or maybe getting 10% of my existing exposure. So why should I give further? So the consideration for the bank is that it should at least be a going concern, or maybe a unit which can convert it into a going concern through infusing some interim finance.
Yes.
Unless that is there, I don't think bankers will be convinced to put money here.
Yes.
As regard your CRP cost, that can be funded through some other alternative, like now there is a provision or regulation for liquidation cost.
Yes.
Similar provision can be brought in for CRP cost also. But that may not be interim finance. Can we put like some upfront money banks have to give to run the company during?
Yes, sir.
Third will be assessment, how to assess the
How to
requirement.
assess.
Because RP will say, may require 5 crore, we say, I want 50 crore.
Yes.
So how to assess that? So that is the third problem with the bankers.
Yeah.
So we have come out with a solution here, like the RP has to give me some visibility about the cash flows during the CRP process. He knows, because he has the handle, he has the visibility, he gets the payments, makes payments. So he has to give me a cash flow of at least 6 months to 9 months or maybe 1 year from the date of applying for interim finance. That cash flow, and then he'll have to give me some rolling cash flow also every month. As I get stock statement from a borrower every month to get a visibility ke where I am in terms of my exposure and my security. So this is very important. He should give me a cash flow for next 1 year. Sir, fifth thing is like how to cover this. Because if I am giving interim finance for a liquidation, I am putting more good money into bad money. So what he can convince the COC that he give me a enterprise value in case this concern, which is a running concern, if we take it and sell it as a going concern, you get an enterprise value. If we take it to liquidation without interim finance, you get a liquidation value. There's major loss of value. Then banks has an incentive to seek giving some, say, good, small percentage, maybe 5% of the exposure, and taking the enterprise value as a recovery will be much better than taking the liquidation value at the end. So that is a critical part, how the RP is able to convince the COC his capability of running the unit as a going concern first, getting a resolution plan at the end of it, and then the resolution plan above the liquidation value. It should be above. So that is the one. And lastly, as you rightly said, the clawback or the recovery, because banks are bound by RBI guidelines.
Yes, sir.
If I don't get my interest for 90 days, my account becomes NPA. So I give some good funds, and 90 days I don't get any interest, my interim finance is declared NPA. So how to find a solution to that? What I suggest is that in this kind of account, there should be monthly payment of interest also during CRP.
Yes.
For other claims, we don't pay interest during CRP, any other claim, all interest installment recovery is stalled. But for interim finance, there should not be any prohibition, so the RP should arrange payment of interest also at least once in 3 months so that account doesn't become NPA. Lastly, COC, it will be very difficult for the RP to take interim finance from all the members. Some may be non-financial institutions who may not be interested. So it's better that you go to one member, maybe largest member, you request him, because he has super priority in any case. He doesn't have to share it with others. Let him charge the higher rate, that should be the incentive. So don't criticize the higher rate. Higher rate is an incentive for sanctioning interim finance. Only thing is, you let one bank take it entirely and then recover at the end of the CRP or liquidation upfront.
Right.
Thank you.
Thank you.
We have already come out with a product here
I see.
from SBI, and the circular is already out. If you apply to SBI today, I think in a going concern, chances are you'll get.
We'll get. I'll look up that, sir. Anything, sir? Thank you.
In the CRP, under the IBC. But you said that in the DIP, in the Section 11 proceedings, the LTL and LTO is working well.
But, working well in the sense, it is there.
There are good sort of
Yes,
response, at least you are somewhere you are writing in the paper.
Yes.
What is your take that LTO in the creditor in control model also can be workable? Like the problem is that the firm is already in a situation where it cannot raise funds. Cost of borrowing and cost of equity both are going to be very, very high. So like the private equity, hedge funds, venture capitalists, they can perhaps take some sort of the LTO conditions or the veto powers along with the successful resolution applicant with the consent of the RP. Something of that sort could also be worked out. I think the LTO could be worked out in the creditor in control
Yes,
model
sir,
too.
because certain companies which are very stretched, like there's a distinction between insolvent companies and companies facing liquidity issues, as it has been pointed out. So certain LTO lenders typically have control motivations. In DIP, what I have read is that they come in with the entire objective of participating in the final resolution and taking control of the firm. So LTO lenders typically are hedge funds or those kind of investors with high risk appetite, and they don't mind targeting small firms because they see some value either in the assets or overall firm. So that kind of model can also work here, but that also has a disadvantage because that may not be workable in the sense that they take a lot of, they want control and governance, through governance. They stipulate so many things. Under a RP control regime, you may not be able to stipulate such things at the outset. This can form part of when the company is reorganized and when there is a new buyer, maybe a LTO lender type of lender can come in at that point of time, sir, is my humble view.
I have seen cases where they are not taking really total the management control.
Yeah.
They are taking some veto rights on some policy decisions.
Yes, sir.
To some sort of secure
some
their
extent.
equity investments or the preference
Yes, sir.
investment. I'm not sure whether it can be working. I mean, but there could be cases, good cases, where the resolution is possible.
Yes, sir.
The hedge funds, venture capitals, or the
But,
private equity could perhaps bail out the
Yes,
company.
yes. In fact, that's why if there is a early consideration on the type of financial profile of the company, then the type of lenders also is very important. So there's a more systematic requirement of approaching this issue early in the CRP process. That is what this paper recommends. Thank you.
Can you make it last question?
Yes, sir.
Raising the interim finance from the company's point of view. From companies, the company which is
RP
going under the
perspective.
CIRP
Yes,
or the
yes,
liquidation
yes,
from
yes.
that point of view. It would be worthwhile seeing it from the perspective of the lenders,
Yes, sir.
because they would have lot of apprehensions in lending the money to them because of their past track record and other things, and because the money may not be get through. Like in US, UK and other countries, there is a big market which is being developed for this kind of interim finance. Those bankers or the non-banking finance companies, those who are willing to give this interim finance to these ailing companies. So have you done any research in perspective of the India that such market is being developed, and what are the apprehensions from the lender's point of view
Yes, sir.
to raise this interim finance?
Yes, sir. As I mentioned, this paper also covered some lenders' views. And in fact, in the limitations, it is mentioned that because of the lending community is very heterogeneous, you have various types of investors, various types of lenders. This needs to be a topic of a separate paper, as far as lenders' views are concerned. But you're absolutely right. All stakeholders' views need to be taken. But the RP, this is from the RP's perspective and a few select lenders in this paper. But the RP has a view on the ground level challenges. This paper focuses on the ground level challenges. So I won't take much of your more of your time. Thank you very much.
Thank you. We have the third paper presentation. The topic is Section 32A of IBC, Conundrum or Protection. It would be presented by Mr. Mayur Juktawat and Mr. Vishal Dave. I request the questioners to stick to a 5-minute time limit because we slightly exceeded it in the past presentation.
A very good afternoon. So after lunch it is very difficult, I know. So today I have a very burning issue. So I think it will help all of us to be more attentive. So section 32A. So as we all know that IBC is the most innovative and piece of legislation. We all know the benefits of IBC. Everyone knows maximization, revival of a company, promoting entrepreneurship. But the most challenge is once the law takes in motion, once the CIRP starts, RP, or if you go into liquidation, the liquidator is the most important person who has to do the job. By taking everyone along in a single boat, together all the stakeholders, right? So one issue came suddenly because we all know that Enforcement Directorate, ED, is the most aggressive, active enforcement agency in India after CBI. I mean Central Bureau of Investigation, not Central Bank of India. So it is the most active. Now whenever a enforcement agency comes into picture, it scatters everything. And in the implementation of any process, it becomes very difficult. So from a lawyer perspective, when ED comes up and sits on the assets of the corporate debtor, RP can't do anything. As in one of the precedent, it has been held in SR judgment that RP or the liquidator is appointed by forum or tribunal, is a public servant. And even any officials of ED are also public servant. So whenever ED comes up in picture, sit over the assets, then everything stalls. And the main objective of this code is a time-bound manner. Because earlier, whatever the recovery laws were there, for years and years together, we lawyers used to enjoy and interpret and go from one forum to another, and recovery was stalled. So it is a time-bound law. But since the new challenge came up, whenever the enforcement agency lodges prosecution, attach the asset, these stalls. So this issue first came up in one of the judgment of JSW, wherein the resolution plan was approved. And as soon as it was about to implement, a Pandora box came up. AD says, now you stop. So that is why it was need of an hour that ordinance has to brought into when Parliament was not in session. So it's good that the legislature from the IBC perspective is the most alert that every time a new issue comes up, it brings an ordinance or the amendment in the law so that the entire implementation process is smooth in nature. So now we talk of 32A, which has brought into the picture. Now what is the object of 32A? Is to protect the corporate debtor and his assets from being prosecuted for any offense prior to CIRP. This is the object. But we need to understand, basically, law is very clear, but at what stage this section will trigger? So this is the most important thing we need to understand. As per the section, it says, when a plan is approved by NCLT, this section will trigger, or when there is a sale of the liquidation assets. So the object is that whosoever comes with a new management will get a clean slate and can start afresh their business. So this is the prime object. So the new management must not be attached with the prior office bearers, directors, promoters, or whosoever who has committed any offense under the Act. Now, though the law is very clear, but still the enforcement agency is like, there is a clash of the titans, that who is the heavyweight, whether it is the IBC or the PML Act. Because normally what happens, whenever there is a statutory powers conferred under any act to anyone, for example, RP having a statutory powers, ED has their statutory powers. So there has been a history in the legislation that when there is a clash of the powers, statutory powers, either one will overpower it and other will not surrender it. And in that case, who is the mediator? It is the judiciary. So a lot of people, it is very easy to criticize courts, but whenever a law comes, and there is a constant practice in our system, the law always goes for the constitutional validity. So all the, maybe any litigant challenge the law under the writ jurisdiction to test the validity, whether the law is settled or not. Some say it is challenging a law is waste of time. But from my perspective, if you say, it's a very good thing. Because whenever new amendment comes, and when the constitutional validity is challenged before the highest court of law, and when the law is upheld by the highest court, that means there is no further interpretation. There is no further confusion. There is no ambiguity in law. So this makes the implementation of that section very easy. That is the reason constitutional validity is very important. It gives the clarity that what is the purpose of the act. And whenever the highest court of law, either they read down the law or they struck down the law. And the intent of the legislature is always defined in the constitutional validity. So again, whenever 32A comes, still it was challenged with the Supreme Court, it was challenged with the Madras High Court, And the court has upheld the law that no, there is no ambiguity, and the corporate debtor has to remove from the regress and its asset so that the object of the IBC could be fulfilled. So this is the constitutional validity which I talked about. Now that comes the interplay. Still, the litigation in here will never end because ED will not going to surrender very easily. So when there are two central acts, two statutory powers, even under section 238 of IBC, we have a overriding effect. Even the law says that the later law will prevail over the earlier law. So these are settled precedent, but then also the ED says no, that it is from the proceeds of crime. So we have the right and we will attach it. You can't do it. There can't be any resolution. So the conflict still exists. Now, I'll come to one practical situation. As I said, that once the plan is approved by NCLT, 32A will automatically trigger. So attachment or anything, maybe confiscation or anything done by the ED has to be removed, or under the sale of asset under the liquidation process. But what will happen, suppose prior to CARP, there is an attachment. And once the company goes under CARP, admission order, very enthusiastically IP is appointed, he goes with an order and takes the possession of the secured assets. And at the gate only he is stopped by the persons, who are you? He says, Bhaiya, I'm a court appointed officer. No, we don't recognize you. You go from here. And if the RP try to mess up, very easy, issue summons, call for the record under section 91 CRPC, you come, give you statement. So this is the practical difficulties the RP faces. And if RP goes to the NCLT, sir, I am doing my job, I went there, wanted to take possession, there is an attachment, kindly help me. You direct the ED to release the attach so that I can start the process at least. NCLT says, I'm sorry, I can't help you. Because I don't have any jurisdiction. Because unless the plan is approved, this section could be invoked under my jurisdiction. So where should I go? The NCLT said, you do one thing, I'll give you one suggestion. You go to PML tribunal or authority. So the RP has to again go to file an application before the authority under the PML Act and has to request, sir, this is a law, this is for revival of a company, tell your ED to release it. No, we'll still let me examine it. So you imagine when a time-bound law is shattered, RP or any other stakeholders is not able to do anything, then what is the issue out of it? And same thing is happening if a company goes into liquidation or during CIRP or during liquidation stage, a provisional attachment comes. So this is a practical difficulty. So now this issue at large is still pending before the Honorable Supreme Court, that if you see the literal interpretation of section 32 says that any offense prior to CIRP, and then in the subclause there is a trigger for at the time of approval plan. Now this practical situation only comes when the law is implemented, and this is the practical difficulty. That is the reason now whether, because RP is an appointee officer under the IB code, obviously my adjudicating authority is the only jurisdiction where I will go if any face problem. If I go to some other forum for taking possession or for lifting the attachment, then the time-bound period of law has make no sense. And even the liquidation process where there is a time-bound period, there is no extension of time is given by the authority on the based on the litigation pending. Because when the assets are not there, what will I do? So in this scenario, the RP or the liquidator, whatever the case may be, when the assets are attached, he has to go to NCLT also, and he simultaneously to file an application before the PML authority also, and at both the stages he has to go for the litigation. Still, this issue will not be settled by any of the proceedings unless the Supreme Court will decide, or if the legislature deem fit, then they have to amend the law and has to clear this ambiguity, and otherwise the object of the IBC for the revival in a time-bound manner will not be achieved. And there are other case laws which my learned colleague will take up the case laws, that how practically when the attachment comes, this happens. In many cases, the liquidator and the RP is called by the ED to give summons, to record their statements. In one of the cases, my learned friend will point out that how they have to face such difficulties. So these are the practical things, and that is where the court will come up and will interpret the law and may read down the law and make suggestion to the legislature. See, this is the practical problem. We are reading down the law and you amend it by way of any way, ordinance or the amendment. So this is the thing, and I'll hand over my learned friend to explain the case laws which are evolved in the present scenario. Thank you.
Thank you, sir. So we know that IBC was actually created to make the process easier, but nowadays an amendment is making the things very difficult for various stakeholders. In one of the such amendment is Section 32A. Now the object of Section 32A, why it was brought in first place, was to safeguard the properties of the corporate debtor from prosecution. Now, if we draw this provisions corollary from other statutory authorities law, there are various judgments given by various tribunals in which a charge created by a state tax authority or a GST authority has been vacated or removed by the way of NCLT's order. Now, in such situation, NCLT has observed that Section 238 will prevail over any other enactment. In present scenario, there are two special legislations. First is PMLA and second is IBC. Now, both the statutes have non-obstant clause, which is an overriding effect clause under Section 71 of PMLA Act and Section 238 of IBC Act. In such scenario, which is already, the law is well established by Honorable Supreme Court, that the later enactment will always prevail. And on the basis of same, various tribunals have given their decisions. Now, in the present scenario, the situation is such that a successful bidder or a resolution applicant, when purchases a company, he needs the company from the scratch. He needs that all the past wrongdoings which has been committed by the ex-management needs to be vanished. And therefore, Section 32A came into the place. Now, the problem which arises here is the trigger point when Section 32A can come into the force. Now, as we read the provision of Section 32A, it states that Section 32A will come into force when the resolution plan is approved or the liquidation of assets has been done under the code. Now here, if the CIRP of a corporate debtor is initiated and and the attachment order is passed by PMLA, RP will have to continue such proceedings before PMLA. Now, in such scenario, RP will not be able to get possession of such properties because there is already an attachment of PMLA, and therefore those assets will not get those assets will not attract any investors because there is already an attachment, which will further create difficulties for RP. Other than such difficulties, there are also difficulties faced by RPs. In Bhushan Power and Steel case, which my senior colleague had already mentioned, it happened that after the plan was approved, ED had made an attachment. Along with the attachment, they also made an allegation against the RP that RP colluded with the ex-management and the finished goods were worth 700 crores were sold. So therefore, RP was summoned by ED. And in the similar cases, my friends are aware that there is a case of PSL Limited, which is a Gujarat case only. The RP was burdened with questions and interrogations by the ED department, Enforcement Directorate, and therefore RB had to approach Delhi High Court seeking protection under Section 32A. Now, PSL Limited case was dealt in detail by Delhi High Court. Delhi High Court made an harmonious construction between the two laws and defined the objectives of the two acts, PMLA Act and IBC Code. The purpose of PMLA acts to prosecute the criminals and not the assets of the assets of the corporate debtor, while the purpose of IBC is to revive the corporate debtor and to make it stand on its own leg again. And therefore, the Section 32A was introduced. Now, even after the assets are sold under liquidation, successful bidder is required to approach honorable tribunals in terms of reliefs and concessions. Now, why these reliefs and concessions are required to be given when there is already a protection which is given under Section 32A? There need not be any separate application filed or a separate protection that needs to be required to be taken from NCLT when there is a protection given under Section 32A itself. Now, what is the role of NCLT in such scenario? It has been already decided by Supreme Court in various cases like Gisuram Patel and Gujarat Vikas Nigam that NCLT is only having a supervisory role. NCLT is only having a limited jurisdiction with respect to insolvency only. And therefore, NCLTs and tribunals hesitate or resist themselves to interfere with other laws because they are already a statutory body and there are agencies which are established to deal with such laws. Now, when we file an application before NCLT and like a Info system case where there was a fraud of thousands of crores, that matter went up to NCLAT as well. But now there are two contrary views of NCLAT as well. The matter is pending before Supreme Court that my learned senior has also already mentioned, but there are two contrary views of NCLAT, wherein one matter NCLAT has stated that PMLA, the trigger point of 32A will only come when the resolution plan and liquidation of the assets are sold under liquidation. While in another scenario, the NCLAT has also held that IBC will prevail over PMLA and therefore no action can be taken against by the ED. In such scenario, there is a requirement of an harmonious construction between the two laws, because if we see the PMLA Act and if we remove such confiscation of properties or attachment of properties, the whole purpose of PMLA Act will also fail. And there will only remain the prosecution of the individuals which has been allowed by Section 32A only. Thank you. Okay. So I'll just conclude it, or you want to conclude it?
Now there is another issue in MSME also. Since there is a relaxation, MSME now under 29A, there is a relaxation that they can give a plan. Now suppose the promoters of MSME are prosecuted under the PML Act. So now since they are 29A, they can give the plan and take back their own company. So whether they will get a benefit of 32A down, there is another interesting interpretation has come up. So if you see the 29A, unless they are convicted, once they are convicted, they becomes ineligible or disqualified under 29A. So unless the trial is pending and they are convicted, here even if they file an appeal and they get a stay on the conviction, again they becomes eligible. So again under the MSME there is again issue. So unless the 32A is not settled, this will be an issue. Yes. We are always short of time. Yeah. Thank you. So any questions, please? Either my presentation was good or I'm not able to make you understand. Yes, but then also we can discuss academically.
But anyway, good presentation.
Thank you.
We would love that if you are having another idea, you can mail to us, we will see that.
Certainly. So this MSME issue, unless I am convicted, I am eligible and under 29A.
It seems you have other ideas too, and then
yes.
we would love to have them.
Certainly.
Please mail to us and we will
One small clarification. How
Please.
many cases you come across on the issue of 32A?
So
So many?
lots of issues. Day in, day out, NCLT is burdened with such applications because during CRP, there is a provisional attachment. As soon as the assets, they go and take the assets. During liquidation also. Now what is happening is that since this is a time-bound law, litigation is pending. On one side, NCLT says we will not extend the time period. And if we plead that, sir, this litigation is pending, unless the asset comes, what I will do? Then they will pose a question to us that what you are doing. So this is the practical difficulty. So we are faced rigid by the pressure from the court, from the stakeholders and everything. So this is an issue which has to be normalized, otherwise the object of the code of time-bound manner will not be achieved actually, and the litigation will be dragged for years and years to come. Thank you very much.
Next up, we have the final presentation for this session. The title of the paper is Streamlining CIRP, a Multifaceted Challenge. It would be presented by Mr. Ishan Jaipuriyar and Ms. Rishika Raj.
A very good afternoon, respectable dignitaries, esteemed member of the panel, fellow researchers, ladies and gentlemen. I am Ishan Jaipuriyar.
Good afternoon, everyone. I'm Rishika Raj. Our topic is streamlining of CIRP, a multifaceted challenge. Through this research paper, we have basically identified 3 problem statements and we are trying to address them. One is at the stage of admission stage and the other 2 being at the time of approval of the resolution plan. So the objective of our paper is that we are trying to streamline the systematic gaps which we have identified and try to come up with possible outcomes which will ultimately help the code to achieve its maximum potential. So Ishan will take.
So I would now like to introduce our first problem statement, which deals with the issue of misappropriation and plundering of assets of the corporate debtor right before the insolvency commencement. This 16th century quote from the Shakespearean play Merchant of Venice assumes some significance in this regard, and I quote, "This bond doth give thee here no jot of blood, the words expressly are a pound of flesh." The Merchant of Venice, Act 4, Scene 1. So this formidable argument was put forth by Portia in order to rescue Antonio from the Jewish moneylender Shylock. This argument signifies the sanctity of the asset that needs to be maintained, and no extra ounce could be misappropriated or plundered. This, under the Indian insolvency framework, is ensured by way of Section 14 of the Insolvency and Bankruptcy Code. The essence of imposition of moratorium under Section 14 is to preserve and protect the assets of the corporate debtor, to ensure a comprehensive resolution which would effectuate better value realization. However, no such moratorium is available to the corporate debtor before the insolvency commencement date. This gives rise to opportunistic and at times predatory behavior by the creditors who rush to appropriate the assets right before the insolvency commencement date, and therefore the hot pursuit of the holy grail, that is the assets of the corporate debtor, begins. It is also interesting here to note what the UNCITRAL Legislative Guide on Insolvency Law has to say in this regard. The UNCITRAL Legislative Guide on Insolvency Law states that the parties from whom the estate of the corporate debtor needs the greatest protection are the debtor and its creditors. This statement emphatically underlines the gravity of the issue at hand. It is now pertinent to draw your attention to a few data points which should set the context for the issue. So on the strength of the data sourced from IBBI, it is observed that the average time taken by the adjudicating authority to admit a corporate debtor into insolvency is more than 270 days. That is more than 9 months, as against the stipulated time frame of 14 days. This itself shows the gravity of the issue at hand. Now, this time duration, which is the interregnum between the filing of the application and the admission of the admission of the CD into CIRP, this time frame, when it becomes longer, let's say 6 months or 9 months, it gives rise to a lot of opportunistic behavior on the part of both the promoters as well as the creditors alike. This could be seen in the case of Mohanlal Pillai versus Virgo Marine Shipyard, wherein the prime asset of the corporate debtor, which was a hopper barge in this case, which was worth around 150 crores, was sold by the creditor, and the adjudicating authority was eventually moved by the promoters for the reversal of the sale, as this was the only asset the corporate debtor had. This throws open a question that when the prime asset of the corporate debtor is in a way misappropriated right before the CD goes into insolvency, what remains of the CD to be resolved? This matter, Mohanlal Pillai versus Virgo Marine Shipyard, eventually went up to the Honorable NCLAT, wherein an interim order was passed. It is interesting to note what the NCLAT had to say in this regard. The NCLAT, by way of the interim order, mentioned as follows: the respondent is directed to maintain status quo in regard to the VM hopper barge until further orders. Respondents shall not move the vessel beyond the territorial jurisdiction of this tribunal. This essentially underlines the need for interim moratorium and the significance of preservation of assets of the corporate debtor. Similarly, I would like to place on record another case law which was by NCLT Bench Court 4. The case's name is DHFL versus Nayati Healthcare. In this case, the Honorable Bench made scathing remarks on the conduct of the creditor, as one of the financial creditors moved under SARFACI without even allowing the 60 days statutory period to pass in order to quickly catch hold of the assets of the corporate debtor right before the CIRP commencement. The bench in this regard made the following remarks. Thus, the above said hurried up acts and omissions on the part of the bank and the corporate debtor indicates that there might be some collusion between them in order to help the corporate debtor redeem the property. Thus, the purpose and the object of this tribunal, while passing the previous order, was only to protect the property in question and to secure rights of all the creditors and also of the corporate debtor. This underlines the fact that how the creditors engage in opportunistic behavior by appropriating prime assets of the CD before the application is admitted, and this in turn throws up situations where either the corporate debtor might enter into insolvency without any prime assets, or would inevitably run the risk of going into liquidation, as all the assets that the CD has been appropriated before the insolvency commencement itself. In this regard, what is also very interesting to note is that the Insolvency Law Committee, being mindful of this anomaly, in its report dated 20th February 2020, recommended the introduction of interim moratorium, stating that the adjudicating authority should be empowered to grant an interim moratorium on a case-to-case basis. Discretion should be granted to the adjudicating authority to determine the need and scope of interim moratorium. However, by way of this paper, the authors beg to slightly differ from the recommendations made by the Insolvency Law Committee. This is done because of the following reasons. We believe that if the adjudicating authority is given right to sort of adjudicate on a case-to-case basis, this would essentially add to the already long-drawn process of admissions. This will essentially add an extra layer of litigation which would take away the prime issue at hand, that is the issue of admitting the case within a stipulated time frame, and this would give rise to sort of peripheral litigation which would eventually not help the case but only delay the processes further. Therefore, we propose an automatic interim moratorium which needs to be introduced by way of a code amendment. Therefore, the paper proposes the introduction of section 13A by way of a code amendment which would read as follows. Save as provided in section 14, where an application is filed under section 7, 9 or 10. An interim moratorium shall commence on and from the date of filing of the application and shall cease to have effect on the date of either admission or rejection of such application. And during the interim moratorium period, the creditors of the corporate debtor shall not initiate any legal proceedings or legal actions in respect of any debt. This would therefore ensure that any SARFACI actions or adverse actions taken by the promoters are curtailed, and the admissions are, the time taken in admissions are also sort of streamlined. Thus, the introduction of interim moratorium would add as an added shield for protection and preservation of the assets of the CD and would ensure the collectivity of the process is not undermined by individual opportunistic behaviors. With this, I would conclude the first problem statement of our presentation. We now move to the second problem statement, which is the need for standardization of concessions and waivers. Concessions and waivers, as we all know, form an essential part of any resolution plan. And the resolution applicants try to get the most of it by putting together all sorts of exemptions and concessions sought from the adjudicating authority. Some of these are also in the nature of conditions precedent, which make the whole plan contingent. It is often observed that the adjudication of such waivers occupy a lot of judicial time, and frankly speaking, most of these concessions and waivers are outside the remit and the scope of the adjudication of the adjudicating authority. This proposition is further underlined and strengthened from the Honorable Supreme Court's judgment in Gujarat Urja Vikas Nigam Limited, Amit Gupta versus Gujarat Urja Vikas Nigam Limited, wherein the Honorable Supreme Court made the following remarks with regard to the jurisdiction that the adjudicating authority has while they are dealing with such issues, and the jurisdiction that the adjudicating authority has with regard to section subclause 5 of the Insolvency and Bankruptcy Code, which is like the fountainhead of litigation when it comes to litigations pertaining to IBC. The Honorable Supreme Court has said that if section 60 subclause 5 is given a broad interpretation to include contractual disputes, it would disrupt the streamlined and time-bound processes under the code. Further, the Honorable Supreme Court goes on to observe, and I quote, for the adjudication of disputes that arises dehorse the insolvency of the corporate debtor, the RP or the SRA must approach the relevant competent authorities and not the adjudicating authorities. Therefore, it is best that the SRA approaches the concerned authorities and not eat up into the time of the adjudicating authority by way of IAs, by way of multiple IAs, which should be specifically kept only for approval of the resolution plan. So based on the above, we conducted a short survey of around 105 stakeholders, wherein we tried to identify the most common reliefs and concessions sought in the by way of a resolution plan. And what is interesting to note here is that the most commonly sought reliefs and concessions are the ones which are most commonly not granted by the honorable adjudicating authority. These include seeking blanket approvals and deemed approvals by way of approval of a resolution plan. The resolution plan also acts as a mechanism to surpass the jurisdiction of other authorities, and it acts as like a blanket approval which could be given to the resolution applicant without approaching the relevant authorities, which definitely the observations of the NCLAT, of the NCLT and Honorable NCLAT in this regard are very scathing. They generally say that that we do not have adequate jurisdiction and therefore you need to approach the relevant authorities. Now, what the paper therefore aims to do is to put in place a standardized negative list of concessions and waivers. This negative list, because a positive list would have been very difficult for us to collate, so we came out with rather a negative list which could act as a guiding light for the prospective resolution applicants to draft better resolution plans and also save the time of the honorable adjudicating authority. Now, my co-author, Ms. Rishika Raj, would speak more on this issue.
So as mentioned by Ishan, the rationale for us is that it preserves the judicial time. So we are proposing a formulation of indicative list of waivers and concessions. So the rationale behind is that it will standardize the process and it will act as a benchmark, and should be on this lines or similar lines of information memorandum which IBBI has come up. So the reason we have proposed this indicative list of concessions and waivers is that we have seen many times what the successful resolution applicants try is they try their luck and populate the resolution plan with ample number of exemptions and demand, which are generally the adjudicating authority does not have the appropriate jurisdiction to grant and is not the relevant platform to hear such demands and exemptions. So therefore, we have come up with such a indicative list of concessions and waivers. Now, if we come to the slide, there are options such as waiver of stamp duty, taxes, fees, transfers, etc., and which are usually not granted by the adjudicating authority. For example, if a real estate sector is there and you have to seek a renewal of RERA license, then you have to go to appropriate authority. So similarly, if this is actually a frivolous litigation and will act as the reason why we propose is that it will save precious judicial time. And for this purpose, we actually reached out to several stakeholders in the insolvency ecosystem, and we saw that about 67% of the stakeholders are of the view that this kind of standardization will definitely help the process. And lastly, to conclude, that this will help us to avoid frivolous litigation and save judicial time, and hopefully better quality of resolution plans would be put forward. So now coming to the other issue, that the third problem statement that we have identified is in our research paper is that what happens when a resolution plan becomes commercially unviable and unfit for the implementation, and yet there is an absolute imposition of that resolution plan. So this question arose in due to the landmark judgment of EBIX Singapore Private Limited versus the Committee of Creditors of EDCOM. Now, if I come up to the CRP model timeline, the CRP regulations, which clearly mention that ideally within 15 days, the adjudicating authority is supposed to hear and approve the resolution plan. However, if we look at the data that we sought from IBBI, we can clearly see in more than 30% of the cases, in vast majority of the cases, it takes more than 30 days. So ideally, the 15 days is not followed. And similarly, we also conducted a survey data in which we saw that majority of the stakeholders were also of the view that it takes at least more than 90 days to approval of the resolution plan. And if we analyze the figure 1 from the data which we received from IBI, if we analyze it, we also came to our notice that it takes an average of 200 days and 200 days, an average of 7 months for approval of a resolution plan. So coming to the next slide, if we speak about elbow room for RA resolution applicant for experimentation and economic legislation. So in this, basically, we try to conduct a survey to understand whether the dynamics of a resolution plan change in due course of time. So in this, again, we saw that the majority of the stakeholders were of the view that it does severely affect the time value money, and also severely affects the viability and the feasibility of the resolution plan. Therefore, the 3 reasons why we believe that there should be an elbow room for resolution applicants for experimentation in an economic legislation. The first being judicial hands-off for an economic legislation. So the landmark judgment of Swiss Revens paved the way for an economic experimentation and set out a clear example why there has to be a scope for economic experimentation in economic legislation and commercial laws, and rather they should not be confined to a straitjacket formula. The objective of any economic law or commercial law is basically to accelerate the economy. And also in the case of Uttam Galva Steel versus Deutsche Bank, it was again reiterated by the adjudicating authority that the current code is in the creditor in control model, and if we give more scope of experimentation, it will definitely help the creditors also to come up with better outcomes in future. And similarly, in today's inauguration session as well, how our IBBI chairman suggested that we need to come up, it's better, the time is the essence of the code and we need to follow the same. The second aspect of our argument is the lack of party autonomy. So just as we know that the preamble clearly emphasizes that there should be balance of stakeholders, so and the current framework is not in uniformity with the same. So now coming to the case of Kundan Care appeal, in which is the only exception in this particular case where the adjudicating authority allowed to modify the resolution plan only when the COC allowed the same. So this is the only exception, and this clearly proves the point and the argument and submission here that the COC, if the COC keeps the larger goal in the mind, which is to resolve the corporate debtor, then it will, then such unique options then definitely be explored. At the same time, if you look at the orders like EBIX, it definitely takes a back step in helping us achieve the objective of the code and also the jurisprudence of the code. Even though in that particular case law, the premise of the argument of the resolution applicant was there are very many material changes which has come up with time to be made in the resolution plan, and also the financial projections and assumptions based on which the resolution plan was made. Therefore, it has, in due course of time, it cannot be implemented and it has become completely unworkable. Yet, the sole focus only remains on implementation of the plan, which has completely now become unworkable and unviable. So if I just quote Unicitral, it's completely silent on that, and the only aspect, if it says about is public policy, it speaks about public policy, and our Indian economy, we have seen there's a shift towards marketism. Therefore, there should be enough elbow room for evolution of the jurisprudence and economic experimentation. And just to lastly quote that even this Asian markets such as Singapore have come up with, has the option. Okay, I'll just conclude in 2 minutes. This has come up with has the option to review the resolution plan, and even though the insolvency can be completed within the stipulated time, which is an average of 8 months. Lastly, I'll keep it brief, the scope of distressed market. As again today mentioned in the morning session, that every aspect on all the stakeholders are interconnected. So similarly, if we see there is already a dearth of capital in the corporate debtor. Therefore, what happens is even the investors are looking, to lucrative options to invest their capital and amount. So if we keep on disincentivizing these resolution applications, there will be definitely lesser, and due to which it will lead to lesser options of better resolution plans. Lastly, what we are trying to achieve with this is the recommendation. So just the two aspects of it. If the adjudicating authority takes more than 6 months of time to approve a resolution plan, then the successful resolution applicant should have an option to modify the plan if the COC allows the same. And the another aspect which we have tried to add through proviso in the subclause 1 of section 31 is that if it takes more than 1 year to approve the resolution plan, then the for the adjudicating authority, then the successful SRA should have the right to withdraw the resolution plan if it passes the litmus test of absolute unviability, which is that only if the committee of creditors allow the same. Lastly, I would like to conclude this presentation by saying code is on the voyage of a discovery, and therefore there is a constant need to scope for experimentation so that we achieve the maximum, achieve its maximum potential, and we reach closer to the preamble which have been enshrined in various case laws. Therefore, lastly, I'll just quote as Rohington Fali Mariam quoted in Swiss Ribbons, to stay in experimentation and things economic is a grave irresponsibility, and right to experiment is a fraud with serious consequences to the nation. Thank you.
Dais is open to questions. Yeah.
Here, like approval of resolution plan and delays. So of course, any resolution plan is basically a revival proposal or rescue proposal, which is based on certain assumptions at the time it is prepared. and of course the IM given by the RP. So these assumptions, as in case of any proposal, loan proposal, it is also kind of a loan proposal, some brownfield project proposal. So these assumptions are valid only up to certain time, maybe 3 months, maximum maybe 6 months. So if you delay for more than 6 months, 1 year, so these assumptions go awry, the valuation are disturbed, and ultimately why the resolution plan fails. But have you also gone into the aspect of section 30 bracket 2, where the provision is for the approval of resolution plan by the adjudicating authority? So what exactly the adjudicating authority has to look into the plan? Supreme Court has made very clear that the adjudicating authority doesn't have to peep into the commercial aspect of the plan. So now only thing remains for the adjudicating authority to look at is section 30 bracket 2, which are 3-4 things which are, you can tick box kind of a thing. You can look at the treatment of OCs, the treatment of dissenting financial creditors, and few other things like implementation committee and all that. So I think that should also be covered. Why there is a delay? The reason of delay has not really come up here. Why NCLTs are sitting on the plan for 6 months. I have seen some of my plans are sitting for 2 years, where the NCLT has to see just 4 things under section 30 bracket 2. These can be looked at by registrar, not even the judge is not required. Registrar can sign and send it before the adjudicating authority. Yes, sir, this is okay, you can approve. So that I think is not examined here. One part, yeah.
Yeah, so essentially what 30 subclause 2 does is it provides a checklist to the adjudicating authority to put a tick mark and at whatever requirements are there, and if those requirements are fulfilled, the resolution plan needs to be approved. However, we have not gone into the broader question of why exactly these resolution plans are not getting approved on time, because as we go by the stipulated model time frame, it is not anywhere stipulated, but it says that on the 165th day, the CIRP is approved by the COC, and on the 180th day, the plan approval has to be made by the adjudicating authority, which is to say that around 15 to 30 days time se zyada nahi lagna chahiye plan approval mein. But however, we are still seeing ki jaise admissions mein hai, similarly it is for resolution plan approvals. Multiple RAs, multiple IAs come before the plan approval. Some of the IAs come at the last moment, and then they say my claim was not accepted on time. Therefore, when the adjudicating authority gets into the merits of these IAs, it is natural that only after the adjudication of these IAs are done, then only the RA, then only the resolution plan will pass. Because once the plan is approved, it becomes binding on all stakeholders, and therefore no other remedy remains. Which is why the equity, NCLT doesn't have an equity jurisdiction, but the principles of natural justice and all the things which we spoke about in the morning definitely comes into play, which definitely adds to a lot.
I think then your suggestion to IBBI based on your research should be that till what stage any dispute against claims can come.
Right, sir, right.
It cannot be like 180th day or 330th day.
So like a limited window of 30 days.
So maybe 30 days or 60 days or 90 days. Right. Similarly, for plan also, any objection of the plan is approved by COC should come within 30 days of the approval of the plan by COC. Because I think Supreme Court in SR Steel has also made it clear that any unsuccessful resolution applicant has no stake in the process. We cannot object to the plan unless the plan is approved. Again, some of the adjudicating authorities are entertaining such. I think those things you may cover.
May I ask one thing, if you permit? Here, you said that interim moratorium should be made mandatory.
Right.
But there is other side of the coin, because section 10 filed by the corporate debtor to get the only for the stall the proceedings under the SURFACE, and there are many cases where section 10 has been opposed by the financial creditors because they are at the advanced stage under the SURFACE to sell the assets. And just to get the benefit of moratorium, section 10 applications are filed by the CD. And there has been many cases, if you may go through, where in section 65, where for malicious and fraudulent initiation cost has been imposed. Therefore, interim moratorium cannot be made mandatory. It has to be on case-to-case basis. Second, you said the time taken by the NCLT, because there is a principle of natural justice has to be followed. If you don't give ample opportunity to any litigant, they will go to the appellate forum and say that we have not been heard. And many cases matter have been remanded back. So that is the reason the time always directory cannot be mandatory. Second, for the approval of plan, there is another issue. There is an amendment under section 79 of the Income Tax Act that if you want a relief of carry forward losses, then income tax has to be mandatory heard. So when you notice to the income tax, because the law says you have to notice to the principal commissioner, but the bench says that you notice to the assessing officer, and then they will come and file an objection. So there they take an adjournment. So on Without hearing them, they will not approve the plan. So this is a practical difficulty. So you can't blame a judicial process that it takes time, because everyone has to be heard. Because before approval of plan, there are many clauses which the bench has to be examined.
Can I intervene?
Yeah.
We can take this out for a conversation.
Please.
All
I'm
right.
just suggesting the practical, because as a lawyer,
No, thank you for that.
these are the things. Thank you.
Thank you, good suggestion. And good presentation, Ishan. Only thing, just a suggestion, what will happen to this plan which will be withdrawn? I mean, the plan is withdrawn, but what will happen to the CIRP?
So once the plan is, so if the plan is withdrawn, either it goes into compulsory liquidation. That is the only option. So, but what I would just quote one more case law wherein it was.
You can put in your paper.
हाँ.
Just suggestion.
So उसमें ये कहा था कि endless resolution से बेहतर है कि liquidation should be all.
You have to go in another session.
Thank you so much.
That was the last paper for this session. We are breaking for tea right now. So, yeah.